In terms of the witness interference allegations that were presented to the judges, and the judges concluded that, yes, there was witness interference, the basis for the judges making that conclusion is, A, they heard testimony from witnesses themselves talking about allegations of witness interference. This testimony was given in closed court. It was not open to the public. But based on some of the public sessions of the hearings that I was able to hear, the witnesses did do things like talk to fellow witnesses about witness tampering, and that evidence was presented in court. And based on filings in the court and the decisions by the judges in earlier this year and last year, the judges had access to documentation that looked into the witness interference allegations. So that is the basis on which the judges made those allegations.
Tom, have we been able to do a head count of how many people have changed their story since this case was first brought?
There are about 5 or so witnesses who testified and recanted in court their testimony. The prosecution had actually asked the court to compel about 9 or 10 witnesses to testify. Only 5 of them showed up. One of them, the court went the extra step of giving that particular witness a particular day to testify. That witness didn't show up. The prosecution went through the legal mechanism in the jurisdiction where the witness was to compel that witness to testify. That failed. So 5 witnesses I know of who testified and recanted their evidence in court.
5 who recanted their evidence, others who are no longer here.
In total, 29 witnesses testified before the International Criminal Court, including the ones who recanted. Originally, the prosecution had intended to present 42 witnesses. Along the way, some of the witnesses, the prosecution dropped from their list because they felt that their testimony was not reliable and therefore there was no reason for them to testify. Others just simply didn't show up.
At this point in time, Tom Maliti, would you say that the ICC bungled the case, which is what the Kenya's president is implying here?
I would not say that the International Criminal Court as an institution bungled the case. I would say that the prosecution, which is the body within the ICC that brought the case before the court, brought a case which initially they thought was strong, and along the way they suffered challenges including witness interference. There are also questions about some of the witnesses who eventually testified, and their evidence ended up being second-hand evidence. It wasn't evidence of things that they actually saw or experienced, and that raised questions about the selection or the quality of witnesses that they were able to get. But the judges also spoke on this matter and said that they are not sure, based on the information that they have, that the prosecution was able to get the best quality evidence. And that's why they made the decision they made yesterday.
It's been 7.5 years since there was the bloodshed that followed the 2007 election. Could the process have been speeded up in some way?
Well, it could have been speeded up if the Kenyan political class had accepted and voted for a local tribunal, which was the first choice or the first option on the table. And this option was available in 2009. When the political class of Kenya rejected that option, then the International Criminal Court process kicked in, and that took its time because the case was not referred to the International Criminal Court by the Kenyan government. The prosecutor is the one who initiated the case, had to seek the authority of the judges to investigate. Then when the judges gave the prosecutor the authority to investigate, the prosecutor then prepared the case, and that took a while. That's why it took this long.
The charges have been vacated. Will Vice President Ruto ever stand trial in your view?
I don't know, but that option is there. The judges, in fact, were very specific that they did not acquit him. And they said they did not acquit him because, based on the circumstances around the case, they didn't feel it would be reasonable to acquit him at this point, which means that the prosecution in future, and that future is, a year from now, 30 years from now, the prosecution, if they get new evidence, they can file a fresh case before the International Criminal Court.
And when President Kenyatta tells us that he cooperated fully and gave full access to the ICC, is that true?
Again, this is a point of contention. The Kenyan government has previously said that it did give the International Criminal Court, or rather the prosecution investigators, as much access as they required. The prosecution says that they did get some access, but not all. And there was materials that they wanted which they didn't get. So both sides have a different story to tell.
Tom Maliti, one final question for you. You heard there Uhuru Kenyatta say that unless its structure changes, African nations need to leave the ICC. Your reaction to that?
This is the idea of reforming the International Criminal Court is a new issue on the table. Previously, when the National Assembly of Kenya has asked the government to withdraw, it has just simply asked the government to withdraw. There was no question of whether the ICC should be reformed or not. And there are two resolutions by the National Assembly, one made in 2010, another one in 2013, and up to now the government has not acted on those resolutions. Therefore, this may be more a position the government is taking in negotiating with the International Criminal Court, as opposed to the government actually wanting to withdraw today or in the near future.